Tripathi, this IA has been filed by Mr. The counsel for the appellant.
Yes.
My lord, we have filed
They have
the
sound copy, my lord, only on 39/20/24.
Is there?
this IA pertaining to the correction of a debt. May I audible, my lord?
VC যাচ্ছে কি আছে? ক্যামেরাটা ঠিক করো। It's okay. It's okay.
তারপর সব
এটা বই তৈরি হইতো ক্যামেরা তো একটা হবে এটা এবারে নিতে হবে খুব মানে কি বল ভাই একটা আপনি শুরু করুন ক্যামেরাটা আপনি পাওয়ার করুন
My lord, let's me come to the internal page 18.
Oh, yes, but that was submitted by the then council.
Yes.
That
Earlier it was dealt with by learned President Government Advocate Mr. Kara is a counsel for central government. He has filed the tie.
That observation is absolutely correct, my lord, because when, my lord, if you also look at order dated 3/2/2023.
3/2/23.
Yes. The judgment was reserved to be delivered subsequently by a region order. Subsequently, lordships put up the matter for specifically said, my lord, to be mentioned. To be clarified, my lord, what was the date? My lord, kindly see the objection I have filed. In the IA, my lord, they have filed that order saying that order of dismissal was 7/10/2010. That's why order is required to be modified, that corrected to be 10. My lord, this order 7/10/2010
yes
was already quashed by the Allahabad High Court.
correct
Thereafter, special appeal was taken up.
correct
And if you lordship look at, I had presented before lordship's my lord the last order, page 35,
flag D
flag D, my lord,
annexure D.
annexure D. That order was passed on 23/2017. And this order was passed pursuant to a division bench direction of the tribunal, of the Honorable Allahabad High Court.
This 23/17
Yes.
is part of the annexure in the writ appeal or writ
So,
petition.
my lord, I don't remember, but that was not there because writ appeal was taken up.
Let me check it then.
My lord.
You have that. You can use that paperless brief. It'll be easier for you.
No, I have checked the file also, my lord. That was not there. But to my knowledge, my lord, I had presented that order before lordships. All those orders I presented.
Mr. Padhi,
Yes, my lord.
you are aware of that 2017, 30/10/2017 order?
No, it was not
Your
awarded,
order.
I was filed annexing the office order dated 7 July 2010, 7/7/2010.
That's besides the issue, Mr. Padhi. Much
Yes.
water has flown. This status of the employee was, the instruction regarding the status of the employee was provided by Mr. Korod, who then was the argument for the appellant. So that he has based his submission on this particular annexure, please mark, where you find in the IA they have filed an objection. Just go to the last page of annexure D.
That objection I didn't have. The copy of the objection I didn't have. Because I didn't receive the copy of this.
Tell that
He has already received.
My esteemed brother is also looking at that. I am looking at that.
I didn't have that copy.
Mr. Kora received on 11.
Mr. Kora hand over
Oh,
the file
acha.
to me, all records except
Oh.
the objection, because that is not with him. If they could have served, then definitely it is in the file. Anyhow, I can let's see me.
Saying that he's not saying that.
But my instruction is there.
IA petitioner is Mr. Padhi, you are there.
Yes, yes.
IA so and so, that is at flag D. Flag C, na kite koile?
Flag C.
Flag C.
Flag C, IA number 9037 of 2023. Mr. IA re likhibe Padhi lane DSG along with Mr. Rakesh Behra, CGC, for the petitioner into bracket opposite party in the disposed of appeal. Mr. B.S. Tripathi, senior counsel, instructed by Mr. Abid Sahu. Abid Sahu for the respondent, opposite party respondent, no?
Yes.
Opposite party. So Mr. Padhi is for the appellant. It is DIG CRPF.
Yes, we have for appellant.
So into bracket appellant in the disposed of writ appeal. Mr. So-and-so senior counsel, instructed by so-and-so, instructing for the opposite party into bracket respondent in the appeal. The IA has been listed before this bench as per the orders of the Honorable the Chief Justice dated 12/9/2024 in the administrative side, as the writ appeal was disposed of by a bench where MS Sahu, J was a member. The IA has been filed for correction of the date of superannuation. Superannuation, Mr. Tripathi?
No, his application for voluntary retirement was rejected.
For date for correction of a date mentioned in the judgment.
On 2010, he was dismissed.
Sir, you go through the judgment. You go through the judgment, everything has been discussed. So why you want that also? In fact, both of us are unable to understand also. And it was upon instruction of the learned counsel for the appellant, the learned central government counsel. And we can't just replicate or redo the whole thing. But anyway, he has brought to your notice. You see that, then you file your rest. You are saying that you are not in
Definitely.
Judgment. As mentioned in paragraph
Paragraph 10 of the judgment, paragraph 10.
Paragraph 10.
Yes, conclusion.
Conclusion. That is, see, coda change kare pe kochanti.
Sir, date,
that is
month of March 2007.
Since the respondent is stated to have retired from service in the month of March 2017, his pensionary benefits shall be revised and refixed accordingly. Quote ends. Are you worried about the 6% of interest? You are yet to calculate that. The clock started ticking. No.
If you
can calculate.
To calculate in different. We have calculated in 2010.
Oh, your voice is getting interrupted and video also.
May audible, my lord? May audible?
No, break break so let us not take your submission seriously. If I reproduce that, it will be difficult. Para 10, page 18. So sentence ta quote kari debe. Since the respondent is stated to have retired from service in the month of March 2017, his pensionary benefits shall be revised and refixed accordingly. Quote ends. It is submitted by the learned DSGI. The present in VC ago likhile hybrid board likhchandi to that the date should be that the date is kete kohchandi apana? Yes, Mr. Tripathi.
7/7/2010.
7/7/2010.
Yes, madam.
7/7/2010. In response, the learned senior counsel appearing for the opposite party, respondent in the disposed of writ appeal submits that he has filed objection to the miscase, enclosing the order dated
cost title लिखी दीजिए particular.
Order dated 20th of March 2017, marked as Annexure D to the objection.
Yes.
Passed by the DIG, Group Center CRPF, Allahabad, rejecting the prayer of the opposite party for VRS.
Yes.
Stop. The learned DSJ submits that since there is a change in the counsel who had appeared for the appellants, he is not having a copy. The learned instructing counsel, Mr. Sahoo, shall provide a copy of the objection to the learned CGC. How much time?
By Tuesday.
Within 2 working days. List on consent list on 3/5/2025.
My lord, may I pray? Can it be 5th? But 3rd I will be absent.
No, you see, this is a break bench. We are having both our regular assignments. We have to. My esteemed.
Then my lord brothers will go.
So basically, I don't think as far as calculation is concerned, it will make hardly any difference.
2010. I am not 2010. I am not disputing the same.
No, it's not a question of calculating till 2010. It is
Then and it was in dispatched, my lord.
Yes, it is calculation of the benefit on the date of superannuation. I don't think there will be difference also in calculation. You ask your officer what the difference would be.
Okay. Yes.
Yes. Working achipara? Working Saturday. Any change, it will be notified if the bench is unable to function, since it is a special assignment.
So yes, tag it.
No, it's better you should go before the regular assignment so that it can proceed. They are getting worried. Maybe this is the after filing of contract. This is the idea that yes. Anyway, but they have not challenged. You are sure?
No, they are not.
Because you would have said this. Yes.
That 7/7/2010 order has been quashed. It
is also submitted. It is also submitted, Senior Counsel Collective. The 7/7/2010 order has been quashed by the High Court of Allahabad High Court. Allahabad High Court. Mr. Padi, that order is quashed also. Please take note of that and you find out.
Yes. I have noted, my lord. I will find out.
Yes. I come to CONTC order kar diyantu list on same date kar do. In view of the order passed in IA number ette likhi debe. So and so. List on 3/5 on consent list on 3/5/2025.
In that content, Mr. Guchhat is with me along with this.
Mr. Deepak Guchhat along with Mr. DSJ, Mr. Padi. No, I was Mr. Guchhat. Mr. Guchhat, actually you are below the vacuum of the Justice Nursing. So he is unable to see you. Yes.
May I please, your lordship?
Kindly speak to the microphone. There is a glass barrier.
May I please, your lordship? My lord, Mr. Mahapatri argued the matter, item number 2, and she is ill, my lord. Some adjournment, my lord.
So, Mahanti, 3/5. Upon Canada?
My Lord, P.K. Swain.
Don't have power. Mr. P.K. Swain submits that in absence of the senior Mr. Mahapatra, in the absence of the arguing counsel, senior Mr. Mahapatra, he seeks the matter may be adjourned
My Lord.
on consent list on 3-5-20-23. 20-25, I'm sorry. Saturday working day jota achi, since it is a special bench, so yes. So the second matter is also pending.
My Lord.
Arising out of
Same order.
arising out of same.
Oblige, my Lord.
Please, your lords. Not the appellant has been convicted under section 302 IPC and sentenced to life imprisonment on earlier occasion. My lord, the case against there is no eyewitness to the occurrence, and
Why it is listed before this bench?
before bench, my lord,
Justice Narsingh.
was why, because earlier disposed of bail application
Yes.
because he was granted interim bail,
Yes. Carry on.
my lord. Because of there was a motive regarding there was a motive dispute the victim, the deceased family was neighbor. So that is why this honorable court is pleased to grant me interim bail for 3 months, saying that you go for interim bail, then we'll consider. So I went on interim bail, and my lord, thereafter in time I surrendered. Surrender certificate I have also filed. Now, so far the case of the merit of the case, my lord, the prosecution case that, my lord, on the night of occurrence.
No change in bench. Justice Narsingh.
Yes, only.
So don't re-argue. Straight away come to best point.
My lord, there is a case of prosecution case that on the night of occurrence, on hearing the noise of the victim, family member, that is PW 2349, they went near the victim, who disclosed before them that this appellant has cut throat. So thereafter, that is the oral evidence, the oral dying declaration paper. My lord, I have contended before, my lord, the evidence of the doctor PW 18, who has stated that has also been described in paragraph 13. That PW 18, he has opined that, doctor opined that the injury throat, which is the cut, my lord, he that cutting with that injury, she cannot touch.
Jafrullah, the conviction, it is post-conviction bail or during
Post-conviction.
post-conviction. So we are not taking up on as far as the merits are concerned. So you argue on the base point where you will say that how many years incarceration?
2019, I'm in custody. I'm in custody since, my lord, 5/7/2019. Continuously I was in custody, and so far the merit is that doctor can state opine that he cannot talk. So that oral dying declaration cannot be considered, my lord. That appears to be doubtful with such injury. But only motive, only because of that there was earlier my lord, in paragraph 20 running case 24, internal case 24, the trial court has hold that there is no clear evidence of motive. But apparently there was a dispute with the victim. That is why this honorable court was hold that you go first interim bail for 3 months.
Were you on bail?
No, I was not on bail. I was continuously in custody since 2019, except interim bail for 3 months, which your lordship was pleased to grant me, and in time I surrender, and no adverse, my lord.
Let us see the dying declaration.
My lord, dying declaration.
PW?
PW, my lord,
3 and
evidence of PW
Before the PW 3 and 9.
2349, all have stated. The evidence of
And acts.
the oral exam running page 10 onwards, your lordship, 9 onwards, your lordship, I can see paragraph 9. On analysis of the evidence of the entire prosecution witness discussed, it is seen that
Not the judgment.
Deposition.
Deposition.
deposition, PW
3.
yes. PW 3.
3.
PW 3.
3.
Your lordship, paragraph 2. The night of occurrence about 2 years back, after taking dinner, I had gone to sleep along with Kavita. Kavita is at about 2 a.m. night. Accused Binod Deepa came and assaulted Kavita by means of a tangia to her right side neck when she was sleeping. Kavita told me that accused Binod Deepa assaulted her neck by means of a tangia. I saw a cut injury on her right side neck. Blood was coming out from the neck. Then the mother of the accused persons, namely Kandriya, had also come to the spot. Informant PW9 along with his wife PW4, Jagdish PW2 also came to the spot. When Kavita disclosed before me that she was subjected to assault by the accused by means of a tangia, hearing the same, the mother of the accused Kandriya left the spot. So that is the crux. And PW9 18, your lordship kindly have a glance to the evidence of the doctor PW18.
Let us see the IO first.
Pardon?
IO.
IO's evidence is at PW 19 mallet.
Yes, let us see the IO.
Mallet, part of PW 19 mallet.
Let us see the cross-examination.
Cross-examination, so far PW 3 is concerned, in paragraph 11.
19, you are referring to 19.
No, paragraph 11, so far confrontation.
Cross-examination of the 19.
Yes. There is no recorded and declaration. That is paragraph 4 onwards. He has stated regarding the investigation.
No, where you are reading?
Pardon?
Where you are reading?
Para 9.
Paragraph. No, my lord is referring to PW 19.
Yes, cross-examination. You have not found that out.
Para 9.
Page internal page 4. Balabhadra Ganda.
Balabhadra Ganda.
Cross-examination by defense.
That is, my lord, that is from cross-examination is all relating to confrontation regarding the what they have exaggerated. That is paragraph 9 onwards. And so far PW 3 is concerned. Pardon?
With your experience of trial, there is nothing in the confrontation.
Pardon? No, nothing. Cross-examination, confrontation. When the doctor is completely ruling out, doctor is complete.
Let us see the doctor.
That point PW 18, my lord. PW 18.
Yeah.
Your lordship may read paragraph 5, then paragraph 7. From the above examination, I found the cause of death was due to deep wound over neck caused by sharp cutting weapon and cutting of large vessel and muscle of the neck, bleeding profusely with aspiration of blood into lungs, causing asphyxia and due to respiratory failure, heart failure. Cause of death is found. Then paragraph 7. It is a fact that muscle of the neck was completely soft than the other skeletal muscle of the limbs. With such injury as found in this case, a person cannot talk. It is a fact that deceased could not have talked after sustaining injury.
Does that match with the ocular evidence?
Yes, that is what.
No. Does that match with the ocular evidence?
Yes,
so that
ocular evidence, all witnesses are saying that.
So when you are asking this as a witness who is a doctor as a matter of kind of a theory.
No, so the injury after.
So does the doctor who had treated the patient, has he been examined that she was not in a condition fit to be making a statement?
He was not treated, Malat. After she installed death, and he opined that after some sustained.
Sir, don't go on a speech. Has the doctor who treated the victim whose throat was slit, has he been examined by the defense or the prosecution?
He is the.
So he's the doctor.
He is the PW18.
So did the patient was received alive to speak? The patient, the victim, the injured victim was received in the hospital alive or dead?
my lord, he was taken to hospital, my lord. Doctor's evidence, the witness my lord, evidence is that subsequently we shifted the
So-
victim to Sonpur hospital in
So
the vehicle.
have you discredited the ocular evidence, asking by in cross-examination who has stated that they have heard this victim saying who attacked or who caught the whatever way?
My lord,
Is there any question put?
that is been my lord.
So doctor is a post-occurrence witness at best for the purpose
No,
of
my lord. When oral evidence, person is saying that deceased has made a disclose.
Mr. Jafrullah, you didn't get.
But certainly not. Whatever lords may ask me any question.
What my lord is saying is that what the doctor has said is a general statement that in a injury of this nature, person cannot talk.
My lord,
That has to be. That's why the question was posed to you. In that scenario, the ocular evidence becomes relevant, and the ocular evidence of the witnesses is that at that time they have used the word say gong hotula, and then she spoke.
it is not my answer.
So it cannot, the doctor's statement in PW8 cannot be taken as a absolute
Yes,
proposition.
because it is
unless you place on record
That
or
is- that
draw
I'm-
the attention of the court
that paragraph
at
7.
some time the
My lord,
still when
your
she
lord,
was
it
alive.
is not theory. PW 18, doctor in paragraph 7 has specifically stated that it is a fact that deceased could not.
Mr. Jafrullah, what is res geste?
Res geste means, my lord, after examination of the witness, if
No,
somebody
no.
disclosed before the section 6 of the...
Res geste is the sequence of events. So doctor is, you ask a doctor regarding his knowledge regarding this particular injury. But to look at the examination in chief,
Yes,
para 1.
on doctor's evidence, my lord.
Yes.
Yes.
Para 1, now you are referring to 7.
My lord,
Look at
my lord.
para 1.
My lord, I was working in senior medical on that day on police requisition as per the order of the medical superintendent. I conducted postmortem over the dead body of the deceased. The deceased was identified with Constable Sivadas.
Exactly.
On external examination.
Mr. Jafrullah, we are not inclined. If you want to, if you don't want to press it for the timing, it is open.
No, I'm whatever your lordship is asking me any question.
Mr. Jafrullah,
We are not asking question because you are propounding a theory that once the postmortem doctor says that the injury is of such nature that the victim could not have spoken. So we sitting in appeal or considering the appeal or maybe in the bail, we have to take note of that, answer that, your proposition. So that is how it's a question of res geste, that whether you have confronted this, that she did not speak, could not have spoken to the ocular witnesses, the persons who have deposed regarding the dying declaration, or the doctor who has seen her alive with the injury and reported that yes, she could not have spoken.
No, the evidence
so that is how you can you overcome paragraph 1 of the doctor's statement.
Evidence.
Kindly listen.
Yes, ma'am.
The question is very simple. Can you overcome paragraph 1 of the doctor's evidence that he has conducted post-mortem only?
No, that is because when the witness says that when they took the deceased to the hospital.
You see, did you conduct the trial? Somebody else has conducted the trial. For the reasons best known, he asked this question number 7.
No,
which doesn't help the defense at least.
It is, when the deceased was reached the hospital, by that time, when the deceased reached the hospital, she was declared dead.
So that it is more so the reason that you have to place on record or bring the attention of the court the evidence. The persons who have been relied on by the prosecution prove that she has spoken. Please appreciate that.
Yes, my lord. I want to appreciate, my lord, my submission before, my lord. I want to limit my submission.
So either if you want to withdraw or we'll dismiss it.
If your lordship, my lord, in this time.
So recording that you have relied on the postmortem doctor's evidence, we reject it. If you accept, we'll record your submission. It's for you. That I can't be more direct than this. After my esteemed brother has said that, then we have to record that you rely on paragraph 7 of the procession of the postmortem doctor to say that the person could not have spoken while alive.
Because it is a case of oral dying declaration.
Don't. You have to accept. Do you want that we'll record your submission that you are relying on the evidence
Yes, my lord, because I'm real. This is the prosecution case. It is the prosecution. Lordship may pass order, my lord. Because it is the prosecution case when the doctor is completely ruling out the oral testimony, saying that sustaining such injury, he cannot.
Can you read the examination where he has ruled out the oral testimony? So that is how I've asked you also. When my lord asked you that, get the hint or not? So have you confronted this?
I'll clarify, your lordship, my lord, because
confronted the prosecution witness with this statement if at all you wanted. And they did the right thing in the trial that they did not confront.
No, that is in trial, my lord, and trial court has a trial court, and trial court advocate has rightly brought out this.
Mr. Jafrullah, you are on top of your brief. But there is something relevant to be addressed or not? You are ahead of me, at least as far as the preparation is concerned. But for me, certain things are relevant. So that is how I'm asking you. So let us not change track. Whenever I ask you, have I confronted, you are yet to answer that.
I have not. Whatever your lordship may ask me any question, I will tell your lordship may pass any order.
Have you confronted the ocular evidence that with the statement of the doctor that she could not have spoken?
My lord, the witnesses, my lord, their evidence. Yes, my lord.
The question, Mr. Jafrullah, is very simple. The question is very simple.
My lord, we have confronted, my lord, we have given a suggestion, my lord, that Kavita has not disclosed this accused has assaulted. That we have suggested.
Abstract
paragraph 40.
Which witness?
PW3 jaha pakhare amar jo evidence ko kara jayi
so what is your answer?
Paragraph 14 we have suggested, my lord. It is a fact that it is not a fact that Kavita had not disclosed.
You are going too fast. You are just missing everything. ଆପଣ କାହାର କୋଉଟା witness ର ପଢୁଛନ୍ତି?
ମୁଁ PW3 ର evidence ଟା ପଢୁଛି ଯାହା ସାମ୍ନାରେ oral paragraph 14 ରେ ତାଙ୍କୁ suggest କରା ଯାଇଛି. paragraph 14 last ପୁରା line ରେ last suggestion ଦେଖନ୍ତୁ paragraph 14 ରେ
ପୁରାଟା ପଢନ୍ତୁ.
It is not a fact that Kavita has not disclosed before me that accused has been assaulted by means of tangia.
It is not matching, sir. ଆପଣ 13 କୁ 14 କହୁଛନ୍ତି.
No, paragraph 13 or 14 ମୁଁ ପଢୁଛି ଆଜ୍ଞା. 14 ଅଛି PW3 ର 14 paragraph ଅଛି. Last line
ସେ ଆପଣ ଦେଖି ପାରିବେ ମୁଁ କୋଟା ଦେଖୁଛି. So it is not that I am having everything. So I have the advantage of clicking it. So it is not a fact that I had not stated. କଣ ପଢୁଛନ୍ତି ଆପଣ?
It is not a fact that Kavita has not disclosed me that accused has
ଆରମ୍ଭରୁ ପଢନ୍ତୁ. paragraph ଟା ପଢନ୍ତୁ.
Paragraph 14 your lordship got it. Paragraph 14.
Mr. Jafrullah, in our brief PW, you are reading PW3.
PW3.
Jasoda.
Jasoda Deep.
So the deposition that we have, paragraph 13 starts with, it is not a fact that I had not stated before IO. Then paragraph 14 starts, it is not a fact that Kavita was having love relation.
Last three line.
It is not a fact, the last 3 lines of that paragraph. It is not a fact that Kavita had
not disclosed me that accused has assaulted by him by means of tangia, and that accused has dealt a tangia blow on her right side neck. And
how does that help you, mister? How does that help you?
Well, we are suggesting she is telling lie. She is telling lie. We are suggesting, and doctor is also confronting.
So you failed to break the PW3. PW3, you could not succeed in breaking. He has denied your suggestion. And you have not confronted that the doctor has
witness prosecution witness is saying that somebody has disclosed, but a cross-examiner will say, he will ask him that yes, because
how to conduct trial right now I don't require your answer.
Now your lordship, probably I am unable to satisfy your lordship, either your lordship adjourn it or your lordship pass order.
No, if you want that, we'll refer to your submission regarding the doctor's evidence.
Problem satisfy କରିପାରୁନ ନା ଆଉ ଗୋଟେ
choice eta. You have been arguing on that point that doctor has said that
is the case. Your lordship may adjourn this matter so that I can satisfy your lordship how to jaha your lordship's query. Otherwise your lordship
no, it's not a question of query. It is a deliberation.
Because in a case of oral dying declaration, how you disbelieve a witness? A person is said.
Sir, don't ask questions.
No, that is so that is the
I can record that you are asking so many questions.
No.
Should I? Or should not?
Yes, Mr. Aprula, we are not inclined. You want to
withdraw
or will pass orders?
Pardon?
You want to withdraw or will pass orders?
Lordsman pass order, my
All
lord.
right. This is an application for suspension of sentence under section 389. It is submitted by Land Council for the appellant, Sri Jafarullah, that the petitioner is in custody since 5/7/2019, and the evidence is, then the conviction is based on circumstantial evidence. And referring to the deposition of the ocular testimony of PW 3, 9 and
3 and 9.
3 and 9, on which the reliance was placed by the learned trial court, and the oral declaration stated to have been made before the said witnesses. It is submitted by Land Council for the appellant that the same cannot be the basis for conviction, taking into account the submission of the expert doctor at PW 18. It is the submission of the Land Council for the appellant that in view of the statement of the doctor PW 18, that with the kind of injury that the deceased suffered, it was not possible for her to talk. This court should not rely on the ocular testimony of PW 3 and 9 and should discard the oral dying declaration. The Learned Council for the state support the order of conviction and submit that the petitioner is not entitled to be released on bail. It is the further submission of Learned Counsel Sri Jafarullah that the petitioner was released on interim bail. Interim bail by order dated so and so, and he has surrendered on due time, and regard must be, and having regard to the conduct of the petitioner, he should be released on bail, since there is bleak chance of early hearing of the appeal, keeping in view the docket position of appeals in this court. We carefully examined the submissions of the Learned Counsel for the appellant and perused the evidence of PWs 3 and 9. And so also the submission of the Learned Counsel for the appellant regarding the improbability of the deceased making any statement with the kind of injury which has been brought out from the mouth of PW 18, the doctor, on a conspectus of materials on record, and the analysis thereof in the impugned judgment. On a conspectus of materials on record, this court is not inclined to enlarge the petitioner on bail at this stage. The bail application accordingly stands disposed of.
So rest of the matters need not worry. All matters will go to 3rd of May.
With permission, my lord, that item number 4, like some correction.
Whatever, sir. No, it was to be taken up on 3rd of May. Whatever, sir. Title bhulele bhi hi jibo.